Hi, my name is Easton Lewis, and today I'll be continuing with Chapter 10, which is the Law of Contracts and Sales, Part 2. At the beginning of this chapter, it describes the methods of discharging a contract. These methods occur by discharge by performance, material breach of contract, discharge by mutual agreement, discharge by conditions, proceedings, and subsequent, discharge by impossibility of a performance, discharge by commercial impracticability, and contracts with the government and sovereign acts doctrine. The chapter goes on with the discharge by performance, and this is fulfilling contractual obligations by doing what was required by the terms of the agreement. The suit for the breach of contract is filed in absence of sustainable performance, which is the completion of nearly all the terms of the contract, including an honest effort to complete the rest of the terms and no willful departure from any means of the terms. Continuing with the discharge by performance is the material breach, which the injured party terminates the contract and sues to recover damages. The breach should be sustainable and intentional, and courts allow a party to cure a material breach if the time period of the contract has not lapsed. The chapter goes on to continue with the discharge by mutual agreement. And this is after a contract is formed, parties may agree to reside a contract. It also is accord and satisfaction, and this is when parties re-sign an existing contract and substitute it with a new one. And then next within the mutual agreement is the novation, and this is when new parties are substituted by four original parties to the agreement. It does not change the contractual duties. Next is the discharge by conditions preceding and subsequent, and this is this condition preceding is a particular event that must take place to give rise to the duty of performance of a contract. If the event does not occur, contracts may be discharged. Next is a condition subsequent, and this is when a particular event that, when it followed the execution of a contract, terminates the contract. And then next is the discharge by impossibility of performances. The impossibility of performance is when a situation in which a party cannot legally or physically perform the contract. The applicable in the following circumstances is death or illness of the promisor, change of law deems promise performance illegal, and destruction of the subject matter. And then next is the discharge by the commercial impracticability. And then commercial impracticability is a situation that makes performance of a contract unreasonably expensive, injurious, or costly to a party. The applicable to a situation that was not foreseeable, and this means that the non-occurrence of the situation was assumed at the time that the contract was executed. Next in the chapter is the sovereign acts doctrine, and this is when governments cannot be held liable for breach of contracts due to legislative or executive acts. Subsequent acts of the government cannot discharge pre-existing constitutional obligations, and limitation does not apply if the legislators pass to deliberately affect an existing contractual obligation. Factors to be considered prior to filing a lawsuit is listed as likelihood of the suit's success, whether the desire to maintain a business relationship with the breaching party, whether litigation can be avoided by arbitrating the dispute through a third party, and the cost of arbitration or litigation as opposed to the revenues to be gained from enforcing the contract. Remedies for a breach contract is listed as avoidance or cancellation of the contract, right to remedy of cure, setting of additional time or extension, price reductions, money damages, and specific performances. The chapter discusses material damages and legal remedies. This lists as dollar sums awarded for the breach of the contract, and compensatory damages is awarded for a breach of contract that results in higher costs or lost profits for the injured party. The plaintiff buyer must show that the defendant seller has reasonably foreseen that the Failure to deliver the goods would lead to the buyer's loss of profits, the amount of damages with reasonable certainty, the damage that everything possible was done to mitigate the damage. Continuing with this topic, describes the punitive damages, which is awarded excess of compensatory damages for deferring similar contact in the future. Also lists as non-mineral damages, which is very smaller amounts awarded to those injured by a breach of contract but cannot show real damages. And next is the liquidated damages, which is awarded by non-performance stipulated in a clause in the contract. The chapter continues with equitable remedies, and this is awarded for the breach of the contract when monetary damages would be inadequate or impracticable. It discusses reconcision, which is cancellation of a contract, and reformation, which is correlation of terms in an agreement to reflect the true understanding of the parties. Next is the specific performance, and this is the court order compelling a party to perform in such a ways as to meet the terms of the contract. It is applied only when a unique object is subject matter of the contract and real estate is involved. Next is the injunction, which is temporary or permanent court order preventing a party to contract for doing something. Continuing with chapters, remedies for a branch of sales contract. And remedies for the seller, a right to recover the purchased item if the seller is unable to sell or dispose goods, and damages if the buyer repudiates contract or refuses to accept the goods. Next is chapter describes e-contracts, and this should include following minimal provisions. Remedies available to the buyer if any of the goods are defective, statements of the seller's referral policy, statement of how the goods are to be paid for, and the form selection clause, which indicts the location and or form where a dispute would be settled should one arise. Disclaimer of the liability provision by the seller for certain uses of goods must be provided in e-contracts, and manner in which an offer can be accepted, clicks of terms that indict agreements to the terms outlined in the offer, and lastly, browse rapid terms. For the last topic of this chapter, it describes e-signatures, and this is Electronic Signatures in Global and National Commerce Act. This allows consumers and businesses to sign contracts online, prevent delays in writing, signing, and returning paperwork. The requirements for the e-signatures is passwords to be entered into a form on a web page. The website must confirm that it belongs to a certain person. And lastly, the use of a thumbprint scanning device. I thought this, obviously relating to Chapter 10, continues with contracts and how they're used. And I thought that was interesting, especially about the e-contract, because nowadays everything is online, especially with COVID. So knowing how they are going about still forming contracts was interesting as well. So thanks.